I'd like now to introduce to you Mr. Paul Moore. Paul has done all the right things. He was raised in Toronto, graduated from Victoria College, and then from the University of Toronto Law School in 1965. He has since that time been associated with the firm of Torrey, Delorier, and Binnington. The one interesting thing I found out about Paul was that he flunked grade 2, skipped grade 3, and flunked grade 4. Now that probably indicates he has some basic problem with simple addition and subtraction and multiplication, but in spite of that, he's going to try and lecture to you today on corporation finance. Paul?
Thank you, Jack. I think my educational background shows that I might be somewhat of a slow starter, so if it takes me a while to get going, please bear with me. Actually, I'm delighted to be here today, having the opportunity of participating in this symposium. I personally believe that the topic is a very interesting one. After all, small business clients constitute a very important part of many lawyers' clientele. Indeed, they're important clients and also very demanding clients. They always want to have things done on time. Usually they're quite punctual and just don't understand if you're late. I once had a small business client who asked me to go golfing with him. We arranged to meet on the golf course at 7 o'clock, and he promised he wouldn't be more than 2 minutes late. Well, he showed up precisely at 7 o'clock, and we proceeded to play a pretty good game. It turned out that he was a left-handed golfer, yet he parred every hole. He enjoyed the day so much that he asked me back again the next day, and again said, 7 o'clock, I won't be more than 2 minutes late. Well, the next day he showed up precisely on time, 7 o'clock, and played another perfect game of golf. But this time, to my utter amazement, he played left-handed golf. Oh, right-handed golf, thank you. Told you I'm a slow starter. I was taken aback a bit, and so I asked him what his secret was. And he said it was quite simple. He said that when he got up in the morning, he noticed which side his wife was sleeping on. If she was sleeping on her right side, he'd play right-handed golf that day, and if she were sleeping on her left side, then he'd play left-handed golf. So I asked him what would happen if she were sleeping on her back, and he said in that case he'd be 2 minutes late. Well, we may not all be as punctual as that. Certainly the Law Society wasn't. I understand that nobody's had an opportunity to read the papers. It's too bad. I've fortunately got a copy of the papers ahead of time, and certainly the other papers are quite worth reading. Naturally, the same as the other lecturers have told you, there's no way I could possibly cover everything in my paper today. What I propose to do is to highlight various points which hopefully will be of some help in the seminar group this afternoon. In addition, I'd like to deal with 2 points which are not covered in the written paper. One of them is the use of the shareholder agreement in financing a small business. And secondly, I'd like to say something on the role of the lawyer in advising a small business client borrowing long-term funds from some sophisticated lender such as the IDB or Roynat or some other such organization. Most of my remarks in this lecture today will deal with financing a small business regardless of the form in which it is carried on. Although certainly when we get into share capital and debt equity ratios and deductibility of interest, etc., most of the remarks will apply only to a corporation. Accordingly, I thought I would use the neutral term company when referring to a small business, and where the context requires, you can read that as a corporation or take it as a sole proprietorship or maybe a partnership. Well, let's begin at the beginning. I think it's important when your client first walks into you, in this case it's Lewis and Trudeau, in the hypothetical fact situation, to ask the basic question to yourself: how much money is needed and where is it going to come from? Now, this might seem like a pretty trite question to ask, but it's interesting. The lawyers usually leave these type of things to the accountants, and I think perhaps that the lawyers should understand the need for funds and the sources. The same question is asked at startup, is asked again when the business starts and continues from year to year. Financing a business is not a one-shot effort at all. It's a continuous endeavor. One of the chief causes of failure of new companies is that they're undercapitalized at startup. Things often get rough, and there are no emergency funds to tide the company over. Well, that's probably something we all know about. But it's equally important to realize that a company will need new funds if it's successful. No successful company is satisfied with what it starts with. It always has to go back to the trough for more. As accounts receivable run ahead and its inventory builds up, it's a tremendous need for funds. The funds a company has at its disposal to use in its business are often referred to as capital in the broad sense. And generally speaking, the capital used in a company can be divided into two basic categories: equity and debt. Equity money is invested more or less permanently in the business by the sole owner or the partners or the shareholders in the hope of deriving profits from the venture. It represents the amount of money that such persons have at risk in the company. No interest on or other fee is usually paid for the use of these funds by the company, and the company has no obligation to pay the money back. Debt or loan capital, on the other hand, represents funds advanced to a company on a temporary basis. In most cases, interest is required to be paid on the debt, and there is a legal requirement on the company to repay the principal. Long-term debt is debt which by its terms matures more than 1 year after the date of its creation, in contrast to short-term debt which matures within 1 year, or demand debt which is payable on demand. Funds raised through long-term debt are often referred to as term capital. You'll hear this term used in the financial press. And this is term capital in contrast to the permanent capital which is invested by way of equity, or the short-term capital and demand capital which is, as I said, advanced on a temporary, very temporary basis. There's a different use for short-term and long-term capital. Term capital is normally used by a company to acquire or improve its fixed assets, such as plant, machinery, and equipment. Or it may be used to buy out an existing business, which again is really the acquisition of fixed assets to a certain extent. Short-term debt and demand debt, on the other hand, are generally used to finance a company's current assets, such as accounts receivable and inventory, and to pay operating expenses. Now, the reason for this, of course, is that the current assets, such as accounts receivable and inventory, should be able to be turned into cash within a period of 1 year, the period within which the current debt matures. So anyone loaning money on a long-term basis to a company will look at the current assets available to service the current debt, and they'll be very concerned that the assets available are sufficient to meet that current debt, because default on the current debt will probably put the long-term debt into default as well. Since fixed assets are not intended to be turned into cash, they're not part of the inventory to be sold, they're really intended to produce profits which over the long term will service the long-term debt and eventually pay it off. Accordingly, fixed assets should be financed through long-term debt and not short-term debt. Just while we're talking about equity and debt, I think it's important to keep in mind that there is a definite distinction. As Don Cameron said this morning, sometimes preferred shares can look an awful lot like debt. Sometimes they have no voting rights, are made redeemable, have a fixed cumulative dividend, and are entitled on winding up to a fixed limited rate of return. Such shares are still equity. They're not part of the debt. And the key thing is that on a winding up or liquidation, they'll rank behind all the debt, including the trade creditors who are maybe unsecured. And again, for tax purposes, the dividends payable on those shares will be treated as dividends, not deductible to the corporation as an expense, and will be treated in the hands of the investor as a dividend entitled to the gross-up treatment. Well, once you decide how much money you need, the next question, I guess, is where's it going to come from? The principal sources of debt capital, or let's deal with equity capital first. The principal sources, I guess, are the owners of the business, the friends and relatives of the owner, and venture capitalists. The principal sources of debt capital are the owners, friends and relatives of the owners, vendors, mortgagees and lessors of plant, machinery and equipment used in the business, lessees of such equipment, or lessors of such equipment, so-called special lenders such as Roynet and the IDB, the company's bank, a very important source, and its trade creditors, and in some cases, when the company is sufficiently large, the public. I've set out in pages B7 to B30 of the printed lecture several points which should be kept in mind when obtaining capital from these various sources. Any one of you could have sat down and said, oh, I can figure that out, owners, friends and relatives, etc. But there's particular problems with each source, and I've set that out in my paper. Just for an example, there's a great danger in taking capital from friends and relatives. The amount of funds provided by this source is usually relatively small, and the important point is that this source can usually only be tapped once and cannot be called upon again when further funds are necessary. And as I said, financing a business is not a one-shot deal. If more funds are required, the reaction of friends and relatives is more likely to be one of pulling out rather than putting more in. Now, this could be very important if the friend, let's say our friend Stanfield or our relative Stanfield, has all the assets of the company charged to secure debt held by him. In 4 or 5 years, if the company needed more funds, it might be impossible to finance the company because all the assets would be charged to secure the debt of Stanfield, and if the debt was not redeemable, maybe he would be unwilling to get out of the picture. I've set out in my printed paper the certain information concerning DRE grants on page B11, which you might briefly refer to, not now, but if you want to spend any time on it. The fact situation does contemplate obtaining money from the DRE program, although I don't think in the seminar groups you'll want to spend too much time on the technical aspects of it. I'd also refer to page B21, where I do set out the bank's role in financing a small business. Now, there's only about 2 pages there, which you might briefly read at the time of the seminar. David Kee tomorrow will deal in much greater detail with the bank as a source of funds for the company. There are certain fundamental points which should be kept in mind by any businessman who's about to embark on a plan of financing. These are the type of considerations that you should keep in mind in discussing the fact situation in the seminar today. In the first place, most companies must issue the kinds of securities demanded by the prospective investors without too much regard for other considerations. This is especially so where the company is relatively new and untried and just starting up. Most investors appear to prefer to advance funds by way of debt rather than equity because of the relative security involved and because of the fact that they're more certain of obtaining an assured rate of return on their investment. Fortunately, most companies also prefer to issue debt securities rather than equity securities. It's much cheaper for the company to issue debt securities than it is to issue equity, because interest is deductible from the income of the company for tax purposes, and dividends are not. This makes a big difference. For instance, an issue of preferred shares carrying a dividend of 7% the company would have to earn on an after-tax basis 14%, assuming a 50% tax rate, in order to raise the same amount of money it would if it issued debt at 7%. So from that point of view, and where earnings are important to a company, debt is considerably cheaper than equity. Another factor that should be kept in mind is that of leverage. This is why, again, why the owners of a business would much prefer to have as much debt as possible in relation to equity, because the more debt there is, the better the leverage working in favor of the owners from 2 points of view, from the earnings point of view and from capital gains point of view. Take an example of a company that earns on invested capital, and by invested capital I mean equity and long-term debt, earns an average of 12% on a pre-tax basis. It would be to the advantage to that company and the owners to issue as much debt as possible, provided the interest rate was just less than 12%. All the earnings of the company generated by the funds received, less interest and taxes, would accrue to the ultimate benefit of the owners. If, on the other hand, of course, the rate of return to the company on the funds invested were to fall below 12%, then leverage would work against the owners and the company. Leverage is a two-edged sword. It can cut and it can slice. Leverage also works with respect to capital gains. Suppose the relationship of equity to debt in a company was 1 to 4. That's for every dollar of equity invested, there were $4 by way of debt. If the value of the company as a whole were to double, the value of the equity would increase by 600%. If, on the other hand, the relationship of equity to debt is reversed, namely $4 equity for $1 debt, and the value of the company were to double, the value of the company would increase by 225%. And of course, if there was no debt at all, then the value would only increase twice. As long as the company has some debt, leverage is working. But as the illustration shows, the greater the debt, the greater the equity. Perhaps a better illustration is the case of the man that has $40,000 and wants to go out and buy a house worth $50,000. He buys the house, pays $40,000 down, and takes back a mortgage for $10,000. The house doubles in value. He's made $50,000, and when added to his original $40,000, he's ahead by $90,000. If that same man went into the same neighborhood and bought 4 houses worth $50,000 each, but only put $10,000 down on each house and took a $40,000 mortgage on each house, in that neighborhood the houses doubled in value, he would make $200,000. And he added to his original equity, he would be $240,000 ahead. Again, leverage can work against the fellow. Take the situation of the man that bought the house for $50,000 and paid $10,000 down and took a $40,000 mortgage. If the house fell in value to $35,000, that would come right out of his hide. As a matter of fact, if it falls in value $1, it comes out of his hide, because equity always gets used up first, notionally. Of course, he'd still have the obligation to pay back that mortgage at $40,000 unless he went into personal bankruptcy. One reason why the holders of debt are concerned about a company being over-leveraged is that in such cases, the equity cushion protecting the debt holders is too thin, for the reason I just gave. This is why, in spite of the fact that investors generally would like to put money in by way of debt, and the owners of the company would rather have the money put in by way of debt, there's a limit. There's what they call the debt-equity ratio that lenders of long-term capital look to very carefully. They want to have some equity cushion to protect them. Living in the real world, you don't have a company with a $3 capitalization and millions of dollars of debt. I would say that as a general rule of thumb, and this is very, very general because it does depend on the type of business and all kinds of circumstances, but I would say that perhaps the ratio of equity to debt in a small business, going to one of these lenders, you probably want to have equity 1, debt 3. If you could get away with that, that'd be pretty good. Much would prefer a 1 to 2 and sometimes even a 1 to 1 ratio. Of course, with large industrial companies, the ratio's got to be more equity than debt. In determining this ratio, the senior lender, be it the bank or one of these institutional investors, will look to shareholders' loans, which technically are debt. But if that's postponed and assigned in favor of the senior debt holder, in that case, they'll count that as equity in making the calculation. One other thing to keep in mind is that flexibility is a very important part of planning the financing program for any company. I gave you the example of an inflexible capital structure where debt perhaps has a charge on all the senior assets and is not made redeemable. The company could run into serious trouble. Another thing might be restrictive covenants. These are restrictions usually framed in the negative that the company will not do this, will not do that. I've set out on page B43 of the printed material several typical negative covenants that lenders of long-term capital quite often ask for. Now, these can be framed as absolute prohibitions. For instance, a covenant by the company that it will not incur any additional long-term debt or any additional long-term debt without the consent of the lender, or that it won't incur any capital expenditures or won't pay any dividends. It's much better if you can negotiate for your client a test rather than a prohibition. For instance, the company won't pay any dividends unless the earnings since the loan have amounted to so much, or that it won't incur any additional long-term debt unless the income of the company for the last 2 years available to service all the debt is such and such, or perhaps tied into working capital, won't issue any additional long-term debt unless working capital is such and such. Another important point to keep in mind, which is quite often overlooked, and that is the fundamental importance of not restricting a company's access to its bank. Now, this could be done by a covenant that the company won't borrow any additional funds without the consent of the lender. Or it could be done by a covenant that the company will not grant security to any other debt holder. There should be an exception in both those cases to allow the company to borrow current funds from its banker. And most sophisticated lenders realize this, that the inventory and accounts receivable are financed by short-term debt, and they will permit that. And secondly, there should be an exception to any kind of covenant that there won't be any security given by the company to any other debtors. There should be a specific exception other than security, maybe a security on accounts receivable in Section 88 and inventory, to the company's bankers. You might have a limit on what they can do, but there should be that flexibility, because if you prevent a company from giving security to its bankers, you're in effect preventing the company from borrowing from its bankers, or else subjecting the shareholders to unnecessary guarantees and pledges of their own assets. Again, sophisticated lenders realize this and should be accommodating. People like Stanfield in the fact situation might not be sophisticated and might not realize this. One final thing I think that it's important to mention, and that is how to value a business. If a company is negotiating with investors to issue securities, it's pretty important that it has an idea of what the company's worth. The type of securities agreed to be issued and their terms may well vary depending on the value of the company and, more particularly, its potential for growth. There are various ways of valuing a company. One is an asset value test. It may be book value, net book value, or market value. Generally speaking, what you do is if it's net book value, you take the book value of the assets, subtract the liabilities, and say that's the net book value. Or you take the assets at market value, do the same thing. Or liquidation values might well be, you say, what could you get on a liquidation for these assets, and then you subtract the liabilities. A more usual method of valuing a business is to apply some earnings multiple to its earnings. This is difficult because you don't know whether to do it on an after-tax or a pre-tax basis. The tax rate for small businesses can vary so tremendously depending whether they're associated with other businesses, depending on whether they've got active business income, depending on the rate of depreciation charged. So many factors can vary the tax rate that it's quite often more meaningful to look at pre-tax earnings and apply a multiple which, as a rough rule of thumb, would probably, if it's a 50% tax rate, be about half the multiple you would apply on after-tax earnings. Just by way of example, if a company were to earn $100,000 after tax, and other companies in the same industry, approximately the same size, are selling at approximately 10 times earnings, and you decide because of that that maybe 10 is an appropriate multiple, you would apply 10 to 100,000 and come up with a value of $1 million. Now, again, you have to look at what the company's doing. Perhaps its earnings are rising dramatically and it's not proper. A 10 times multiple is too low. The three important things, of course, that any investor looks to is management, security, and most importantly, growth potential. So in choosing an earnings multiple, the growth of the company has a factor. Certain adjustments often have to be made. For instance, in our example, in the fact situation, if you look at the statement of profit and loss, you'll see $22,000 salaries and benefits. And if the fact situation says there are 3 employees, there's Trudeau, his son, and Cowett. Well, assuming they're all paid the same, that's just a little over $7,000. Would that be a proper charge, or is maybe Trudeau not taking everything out of the company that he would normally do if he were working on an arm's length basis? Maybe he wants the earnings to look good. So you might deduct something from the $13,600 earnings shown before applying the multiple. Or it might work the other way. The shareholders might be robbing the company blind with bonuses and large salaries. And you want to know what this company earns, you'd make an adjustment and add that back before applying the multiple. Well, those are some basic considerations which should be kept in mind in financing a business. Let's move on and say, well, we've got all these in mind now. What securities should be issued? Who gets what? Again, on pages B51 to B75 of the printed material, I've set out many of the common securities which are issued. I've listed common shares, Class A shares, preferred shares, the various types of bonds, debentures, etc. Talk about some of the security that might be given, options, rights, warrants. Just briefly, I'll mention a few highlights. Of course, every company will have a class of common shares. These are the ultimate equity shares of the company. They have no restrictions whatsoever set out in the articles, except if it's a private company, a restriction on transfer perhaps. As such, they are fully voting. Now, the holders of the common shares are the ones who benefit by the growth of the company, because there's no limitation with respect to the amount of income that can be paid to them. It's completely in the discretion of the directors. And there's no limitation on the amount of assets which can be distributed to them on a winding up, subject in both cases to the prior claims of everybody else. They're the most junior shares, but they also have the most potential. Where the owners of a company are willing to give up some equity, but are not willing to give up a voice and control, the company may create and issue another class of shares very similar to the common shares, quite often called Class A shares. There's no magic in that name, but that generally is the name that is used. These are special shares under the Business Corporations Act, or another class of common shares under the Canada Corporations Act. They have the same attributes as common shares, except there's no right to vote, or there's a right to vote that's so restricted that for all intents and purposes it does not exist. As these shares are fully participating in profits and in assets on a wind-up, they too are the shares which can grow in value. Now, I mentioned briefly preferred shares. I think I won't say anything further right now on them. There's all kinds of attributes that you can attach to preferred shares. In the Business Corporations Act, you've got one class of shares that must be common, and all the others are special. And the special shares may be called preferred shares in certain circumstances, or deferred shares in certain circumstances. There's no magic in the name again. The Federal Act talks about preferred shares or preference shares. I can't remember which. One says preferred, the other says preference. Basically, you can have the same attributes, or at least I should say you can accomplish the same thing whether it's federal or provincial. There are a few things like common shares being purchasable by the company that might influence your choice of jurisdiction in incorporating a company. I've set out on pages B55 to B61 the various attributes that can be attached to preferred shares, and you may want to look at them. Long-term debt, I guess the only thing I'd say there is quite often long-term debt is evidenced by debt instruments called bonds or debentures. Again, do not be fooled by thinking that there's any magic in calling a particular instrument a bond as opposed to a debenture or a secured debenture or a floating charge debenture. The terms bond, debenture, and note do not have any precise legal meaning by themselves. Only by examining the terms and provisions of each instrument will you discover its true nature. In common parlance, a bond is an obligation to pay money secured by a fixed charge, usually on land, and often on other fixed assets of the issuer. It often contains a floating charge and all the other assets not charged by way of fixed charge. Sometimes when the land is the most important asset, it's called a first mortgage bond or a mortgage bond. On the other hand, a debenture is probably more commonly applied to an unsecured debt obligation, or a debt obligation secured by a floating charge only, although you sometimes have a debenture which is secured on fixed assets, in which case it's quite often usual to call it a secured debenture. Indeed, those fixed assets may constitute land, but if land is the most important part of the fixed assets, then again, as I said, you'd most likely call it a bond. In my paper, I deal with income debentures as opposed to participating debentures and how they might be used in certain circumstances. I don't think they would be applicable to the fact situation, so I won't deal with them now. The one thing I didn't mention in my paper, and that is the use of shareholders' agreements as a tool in planning the financing of a small business. I think they're probably a very valuable tool, and very few small businesses with more than one shareholder would be without a shareholders' agreement of some sort. The reason for this is that without a shareholders' agreement, a minority shareholder is in a very vulnerable position. Unless there is some provision for cumulative voting contained in the articles of the corporation, he will have no say in the choice of directors. If he himself is a director, he can be removed at any time by a majority vote of the shareholders in an Ontario company, and if it's covered in the bylaws, then of a Dominion company. If he is employed by the company and does not have a good employment contract, he could be dismissed on minimum notice and he's without a job, or he might have his salary cut. He has no assurances whatsoever that dividends will be paid on the class of shares he holds. This could be the case even where he holds cumulative preferred shares, because there's no obligation on the directors to declare a dividend. There's only a restriction that they can't pay a dividend on the common shares until they pay a dividend, declare and pay dividends for the various years on the preferred shares. Of course, once a dividend is declared, then it has to be paid on a share-for-share basis to all the shareholders of the same class without discrimination. But if the controlling shareholders are also employees of the company, they can often strip the company of its surplus funds by paying themselves large salaries and bonuses and do away with the necessity of declaring dividends entirely. Now, you can talk about fraud on the minority and the shareholder's cause of action, but in 99% of the cases, the minority shareholder has got a hard time proving his case. Again, a minority shareholder would have no say in whether the company will issue further shares. And unless there were an adequate preemptive right in the articles, he would be stuck. He could start off owning 10%, and the company could issue all kinds of shares to other persons, friends, maybe the majority shareholders. The minority shareholder would find himself with 5% of the outstanding shares. He would be diluted in half. As Ron Appleby has already indicated in his printed paper, the tax consequences of a corporate act may have very significant different results depending on the individual shareholders. A good case in point is the situation that arises on an amalgamation. The majority shareholders, if they have sufficient shares, might get a tax-free rollover, whereas the minority could be left out in the cold. So without a shareholders' agreement, a minority shareholder could be in a very tough position. And worse yet, in spite of all this, no dividends, he's fired, no income at all, no say in what the corporation does, he can't even get rid of his shares. Probably it's a private company, and therefore the transfer of shares must be approved by the directors, who would be controlled by the majority, or else the articles might provide that an approval must be obtained by the majority shareholders themselves. This is why a shareholders' agreement is necessary. One important matter that the agreement should cover, which I don't think I've mentioned yet, and that is what happens if a shareholder does want to get rid of his shares, or if he dies. It's a private company, and it's quite usual to provide some kind of buy-sell arrangement or some kind of right of first refusal. Very, very briefly, a buy-sell agreement might provide a shotgun type of situation where a shareholder wanting to sell may offer his shares to the other shareholders. They have two options, and only two options, one of which they must accept. They can accept the offer and take the shares, or they can offer their own shares to the original offeror at the same price. And in that case, the original offeror is obligated to take up the shares. The virtue of that, of course, is that it means that the price offered usually is quite fair. It has a sobering effect. A right of first refusal, of course, is the same type of thing that I'm sure you're familiar with in land, that if you're going to sell the property, the shares, you offer them first at the same price you're willing to accept to the other shareholders, and if they accept, fine. If they don't, you're free to sell for a period of time on those same terms. There are innumerable variations possible. Finally, I'd like to talk about the role of the lawyer in advising the small business client who is borrowing long-term debt from somebody like the IDB or Roynat or any institutional lender. Usually, the loan will be made pursuant to a loan agreement. This is signed by the lender and by the company. The lawyer advising the client should look at the loan agreement quite carefully, and this should be done before it's signed. Now, quite often this isn't the case. The client comes into your office and said, here's the loan agreement, do the documents. The loan agreement will not only set out the terms of the deal, the amount of money, the security to be given, the interest rate, but will probably contain all sorts of warranties on the part of your client and certain conditions. that must be satisfied before closing. If you're acting for the company, you should review the warranties with your client and be sure that he understands what they're saying and the legal consequences of them, and you should satisfy yourself that they're accurate. You might have to go and check the articles of the company to see whether it has the corporate power it's warranting it that it has, or if it says there are no agreements which would restrict something the company wants to do, you would check and make sure that that was in accordance with your understanding. The company's accountant should also be brought in at this stage to check the agreement, not just from the point of view of the deal and whether it's going to work, but from the point of view of the warranties to see whether they're reasonable and whether the company can give them without fear of liability. One important warranty that the company will probably be asked to give, especially if there's any security involved, is that the company owns its assets free and clear of all encumbrances, or subject to the encumbrances which would be spelled out in the agreement. And again, you'd probably have to do some sub-searches, or at least satisfy yourself you were reasonably familiar with your client's affairs to know that that warranty was accurate. Perhaps the most important warranty that your client will be asked to give, and that is one relating to the financial statements of the company. And I know that a lot of lawyers will fight, they will only want to have audited statements warranted, but the lender will most likely insist that the most recent financial statements be warranted, whether they're audited or not. Now, the company or the client can take great comfort if the statements are audited, and if they're not audited, I would suggest that perhaps the auditor could be asked to give a cold comfort letter to the client. Sometimes the lender wants the cold comfort letter himself. Such a letter states that although an audit has not been conducted, or if one's underway, although it has not been completed, and that the auditor cannot express any opinion concerning the financial statements, it doesn't know of anything that would make the warranties untrue, or doesn't know of anything that would expose the company to undue liability. It's couched in careful language to protect the auditor from liability, but it's cold comfort to the client. The warranty of the financial statements will basically say two main things, although there are several points that arise from the two things which are usually warranted separately. First of all, it will probably talk about the financial position of the company as at a static date. It'll say, as at this date, the financial position of the company is properly represented by the balance sheet, and that'll be the date of the balance sheet. And this is why the lender wants the most recent date possible. It's not interested in what went on 6 years ago, or 5 years ago, or 12 months ago, or even 6 months ago, if they can know what happened 3 months ago because it's more recent in time. From this warranty as to the financial position of the company, that the statement accurately reflects it, naturally follows that there are no other liabilities, or else the statement wouldn't accurately reflect the financial position. Although it's very usual to have a separate warranty and the statement also reveals all liabilities that the company had at that date, and it doesn't have any other ones. It also follows that the tax position at that date, or certain aspects of the tax position, are adequately reflected. Although this is usually expanded upon, and there's a separate tax warranty that all taxes have been paid and all returns are in and assessments are made and so forth. The second aspect of the warranty on the financial statements, and certainly a lot of people do not include this, but it really should be included, and that is on the operations of the company. In other words, a statement as to a period of time as opposed to a static date. The warranty would say that the statement of profit and loss, or maybe just the financial statements, show the results of the operation of the company over the period covered by the statement, or the period ending on the date of the balance sheet, which is the final date of the statement of profit and loss. If the reason the lender is willing to put up the money is that the company's been profitable for 2 years, then the lender will want the statement of profit and loss for 2 years to be warranted. It's not that interested in the balance sheet 2 years ago, but it certainly is in the earnings for the 2-year period that it is relying on in advancing the funds. Now, it's also customary for the company to warrant that there will not be any material adverse change in the financial position or the operations of the company from the date of the financial statements to the date of closing, although it's much preferable from the company's point of view to make this a condition and not a warranty. The reason for this is that a breach of a warranty gives rise to damages or claim for damages, whereas non-fulfillment of a condition merely lets the person in whose favor it runs out of the deal if in fact it's not fulfilled. Now, the loan agreement is important from the lawyer's own selfish point of view, let alone the client's point of view. It is the master document that will control everything that's done in the financing. It will normally spell out what documents have to be delivered to the lender at the closing and set up a timetable. Documents required most likely would include a legal opinion from the company's lawyer and a certificate of the president or the principal shareholder as to certain facts. From the form of the agreement, the company's lawyer will ascertain the work that he's going to have to do in order to give the opinion. Sometimes the lender will not require an opinion from the borrower's lawyer, but will require as a condition of closing the deal that the lender's own lawyer provide a favorable legal opinion. Now, in any case, the loan agreement invariably will say that the company pays the legal fees of the lender's lawyer. And for this reason, it's probably more economical for the small business to have its own lawyer, which is familiar with its affairs, give the main opinion. Although, again, sometimes the lender won't be happy with the lawyer involved and will want two opinions. As to the mechanics of the opinion, it will invariably be dated the date of closing, and it speaks of this time and only as of this time. If some action, such as the registration of the trust deed, cannot be completed until after closing, the opinion should not say that all due registrations have been effected. Similarly, if the opinion, or if the, let's say a debenture, contains a floating charge on all the property and assets of the company, both present and future, the opinion should not say that the floating charge validly covers all such property. At the date of the opinion, namely the date of closing, the floating charge does not cover future property not yet acquired, or all the property located at such and such a location, whether now owned or hereafter acquired. Well, a fixed charge just wouldn't cover property not yet acquired, and who knows when it finally is acquired, it might be subject to some encumbrances. In such a case, the opinion should say something to the effect that the debenture constitutes a first floating charge on the assets and undertaking of the company. And that, without saying anything further, means the present assets and undertaking of the company. And then it would probably go on to say, and is expressed to cover all property hereafter acquired. The opinion will normally be addressed to the lender. If the lender's lawyer is also giving an opinion and he's relying on the borrower's opinion, the lawyer for the borrower's opinion, the opinion should also be addressed to him to establish privity. So in case there's any action against the lender's lawyer, he can always claim over against the borrower's lawyer. So it's important that you have that opinion, if you're acting for the lender, to make sure it's addressed to the persons on who are relying on it. Now, just very briefly, the opinion itself will probably set out the scope of the investigation undertaken and the documents examined. For instance, if you're giving an opinion on the incorporation of a company and that it validly exists and it's in good standing, you'd probably say you've looked at the letters patent and supplementary letters patent and bylaws, and you've got a certificate of good standing, and based on the foregoing, I'm of the opinion that. Quite often, if security is involved, you're going to be giving an opinion on security and registration. But in order to do this, you'd have to rely on the words of the officers of the company. For example, the lawyer would not be able to give an opinion that there are no liens registered against the company's assets unless he searches. And he'll not know where to search unless he knows where the company carries on business. Indeed, he won't even know what assets the company has unless the company tells him. So it's very customary, again, bolstering your own point of view, so that if you're sued in a negligence action for giving a careless opinion, you can say, look, I relied on a certificate of the company's officers as to where the company carried on business and where it owned its assets, and I searched in the county court offices and the registry offices of all those jurisdictions. And I'm not negligent, even though the certificate might be wrong. You acted reasonably. But be sure you're acting reasonably. If, in fact, the lender sends you a certificate and says, get the principal shareholders to sign this, and you ship it off, and it comes back full of blanks, you couldn't reasonably rely on that. Again, if it contains certain facts that you knew to be wrong and you knew your client realized that they weren't accurate, you couldn't rely on that in an action against you. Quite often, the lender will want a certificate addressed to him as well. Again, he'll want to rely on the certificate. It might be that the lawyer acting for the company or for himself was not negligent, but the certificate is false. If the certificate is addressed to the lender, there's no question that the lender, or there's less of a question that the lender relied on the certificate and could maintain an action. Indeed, it's quite common for the lender to ask for a certificate stating that there are no material adverse changes in the financial position of the company or the results of its operation from the date of the balance sheet to the date of closing. Now, I said earlier that a company really shouldn't warrant that because the facts are beyond its control. Who knows what's going to happen? And if a material adverse change arises, why should the company have to pay damages to the lender for loss of opportunity or whatever the situation might be? The lender should just be able to get out of the deal, and therefore it should be a condition. But if at the closing, the lender says to the company, is this condition fulfilled? And the company says, yes, there's been no material adverse change, and it turns out later that there was a material adverse change, well, the condition expires on closing, and there's no claim for damages unless, again, there's a certificate that the lender relied on, and on that basis, the lender will have a claim against the borrower. One other reason for getting a certificate, it usually goes on and says something like, all the warranties contained in the loan agreement are still valid and as if made today. Updating the warranties. This does two things. It covers usually would cover the period from the time the loan agreement has been signed right up to closing. And secondly, it makes sure that the warranties do not merge on closing. Now, I think that's really all I have time to say, and I hope that'll help you in the lecture group. One further thing I'd just like to point out on legal opinions. This is an area of law I'm sure everybody's interested in. There's an excellent article that appearing in the Business Lawyer, the April 1973 volume of the Business Lawyer, called Legal Opinions in Business Transactions. There's very little written on this, and I found it to be a very good article, and anybody who will be advising the small businessman on financing should really take a look at that article. It's the April 1973 volume of the Business Lawyer, and it's entitled Legal Opinions in Business Transactions by James J. Field of the New York Bar. It's on page 900 and something near the end. Well, thank you very much for your attention. I enjoyed it very much.